Rule 5.3 Responsibilities regarding non-lawyer assistants. Comment share. Law firms and associations. 1. Paragraph A. Requires lawyers with managerial authority within a law firm to make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that non-lawyers in the firm and non-lawyers outside the firm who work on firm matters act in a way compatible with the professional obligations of the lawyer. See comment. 6. To Rule 1.1. Retaining lawyers outside the firm. And comment. 1. To Rule 5.1 Responsibilities with respect to lawyers within a firm. Paragraph B. Applies to lawyers who have supervisory authority over such non-lawyers within or outside the firm. Paragraph C. Specifies the circumstances in which a lawyer is responsible for the conduct of such non-lawyers within or outside the firm that would be a violation of the rules of professional conduct if engaged in by a lawyer. Non-lawyers within the firm. 2. Lawyers generally employ assistants in their practice, including secretaries, investigators, law student interns, and paraprofessionals. Such assistants, whether employees or independent contractors, act for the lawyer in rendition of the lawyer's professional services. A lawyer must give such assistants appropriate instruction and supervision concerning the ethical aspects of their employment, particularly regarding the obligation not to disclose information relating to representation of the client, and should be responsible for their work product. The measures employed in supervising non-lawyers should take account of the fact that they do not have legal training and are not subject to professional discipline. Non-lawyers outside the firm. 3. A lawyer may use non-lawyers outside the firm to assist the lawyer in rendering legal services to the client. Examples include the retention of an investigative or paraprofessional service, hiring a document management company to create and maintain a database for complex litigation, sending client documents to a third party for printing or scanning, and using an internet-based service to store client information. When using such services outside the firm, a lawyer must make reasonable efforts to ensure that the services are provided in a manner that is compatible with the lawyer's professional obligations. The extent of this obligation will depend upon the circumstances, including the education, experience and reputation of the non-lawyer, the nature of the services involved, the terms of any arrangements concerning the protection of client information, and the legal and ethical environments of the jurisdictions in which the services will be performed, particularly with regard to confidentiality. See also Rules 1.1. Competence. 1.2 Allocation of authority. 1.4. Communication with client. 1.6 Confidentiality. 5.4. Professional independence of the lawyer. And 5.5. Unauthorized practice of law. When retaining or directing a non-lawyer outside the firm, a lawyer should communicate directions appropriate under the circumstances to give reasonable assurance that the non-lawyer's conduct is compatible with the professional obligations of the lawyer. 4. Where the client directs the selection of a particular non-lawyer service provider outside the firm, the lawyer ordinarily should agree with the client concerning the allocation of responsibility for monitoring as between the client and the lawyer. See Rule 1.2. When making such an allocation in a matter pending before a tribunal, lawyers and parties may have additional obligations that are a matter of law beyond the scope of these rules.